Good evening, everyone. My name is Izzy, and I would like to welcome you all to the Harris Law Firm's webinar series, Wiser Together. Tonight's webinar, we're going to be discussing Bitcoin and other forms of cryptocurrency in Colorado divorce, and we are incredibly grateful that you are all able to attend. As a member of the Colorado community for over 25 years, the Harris Law Firm has always tried to give back. This and future webinars are a free service that we provide to that community. Now, I would like to introduce our presenter today, Rich Harris. Rich is the managing partner of the Harris Law Firm, one of Colorado's largest divorce and family law firms. Passionate advocate who prioritizes personal attention, Rich has been named among the best lawyers in America, Colorado super lawyers, and a top lawyer of Colorado by the Denver Post. Outside of the courtroom, Rich has published articles across a range of family law topics, as well as co-authoring the Colorado Family Law Deskbook. He's also actively involved in many international and domestic humanitarian organizations, including the Road to Hope, a nonprofit dedicated to promoting the oh my goodness, a nonprofit dedicated to promoting development in Haiti. Without further ado, Rich, I'll turn it over to you.
All right. Thank you very much, Izzy, for that very kind introduction. Welcome everybody who's joining us this evening. I hope you're safe and healthy wherever you might be, whether that's in your office, your home, or what have you. I'm really glad you did join tonight. This is an important and emerging topic in the family law courts. It is very important that you be well informed if you have any cryptocurrency in your divorce, whether that's assets that you own or your spouse owns, or very importantly, that you suspect your spouse owns. It's very important that you protect yourself, and we're going to talk about that tonight. This is frankly a newer area for everybody. Cryptocurrencies didn't even exist as recently as 6 or 7 years ago, at least not in any prominent manner. Bitcoin wasn't there. It's very likely that a lot of judges have not even seen these cases yet. So it's important that you be informed, ask the right questions, you direct your attorney and other professionals to ask those right questions, and that you're as prepared as possible. With that being said, let's go ahead and get started. Here's how I'm going to organize my remarks for tonight. First of all, I'm going to give a bit of an overview about cryptocurrency, kind of lay the groundwork here. Some of you on this call may be far more of an expert than I am, but I'm well aware there are a number of people that hardly understand this stuff, and it's new to, so bear with me as I go through some of the basics here. Then we're going to talk about the legal considerations involving these assets, particularly in the family law courts. We'll talk in particular about how these assets are valued and then potentially divided. We'll talk about some of the strategies that you should be thinking about in order to protect yourself and argue as strongly and persuasively as you can for a fair division of these assets. And I'm going to fix this shade in just a minute. And then we'll get into some of the Q&A. Bear with me 1 second. I'm going to fix that shade, everybody.
It's that time of year again, Rich. The sun's coming down when we do these webinars.
Yeah, how about that? Seasons are changing.
It does that every year. Thank you.
Go figure. So I just performed a very low-tech fix to a high-tech problem on our Zoom screen here. I just moved the shade. Anyway, not interesting, but let's move on. First of all, what exactly is cryptocurrency? As you can imagine, the term comes from crypto, which means hidden, or something that's not obviously discernible, and currency. This is money that is non-traditional. And what it is, Cryptocurrency involves digital assets. These are assets, they're money, but they're not issued. This money product is not issued by any central bank, such as a United States Federal Reserve that issues dollars. It's a new form of currency that only exists in the digital world. Sometimes there are tangible physical manifestations of these assets. You can sometimes get coins or certificates, but the actual assets are contained out on the web. They're digital assets. And what they are involve a technology called blockchain. Without boring you, basically blockchain is a set of numbers out there in the web that cannot be changed. They're decentralized and they're run not by anybody, but they're issued by different entities. The most prominent of these include Bitcoin, and on the slide here is the logo for Bitcoin. Another one is Ethereum. There are literally thousands of different kinds of cryptocurrency. The law, frankly, is struggling how to handle this, but the basic concepts apply to all the different kinds of digital currency out there. Like I said, the most common are Bitcoin, Ethereum. There's something called stable coins, there's altcoins, and there's new ones coming about every day, literally. These are unique digital assets. They're different from traditional assets because they're not tangible, they're not physical assets. They're only out there in the digital world. It's most similar to investments, such as securities like stocks and bonds. You can actually obtain a stock certificate, which evidences your share of ownership in a company, but that's just the evidence of it. Your shares are not physical assets. And that's what these cryptocurrencies involve. So, like I said, judges are struggling to handle these assets in divorce. And I use the term assets deliberately because that's the key to all of this. Cryptocurrency is an asset. It's subject to division. It's subject to valuation, just like any other asset, which a judge must divide. What's different here, of course, is that they're not tangible, and there are other important differences here. First of all, you have this huge problem that these assets are not common. By anonymity, we mean they're not subject to easily finding on statements. You don't see them typically on reports or bank statements. They're not issued by a centralized entity. For a bank account, for example, it's easy and common for us to demand bank statements. And if we don't get them, we can issue a subpoena to the bank, who then will be required to turn over the statements. Sometimes in these cases, we don't know what form of cryptocurrency exists. And even if we did subpoena one of these entities. Another really big challenge here is that these assets are incredibly volatile in terms of their value. They go up and down a lot. Now, in general, Volatility is not a unique problem in divorce cases, volatility in value, I should say. If you can imagine, for example, the most traditional assets we're dividing in a divorce would be a piece of real estate, like the family home or a retirement account. If the divorce case takes several months to process, which is typical, there's going to be changes. There are going to be changes in value between the time, first of all, you separate, the time you file, and the final divorce decree. Under Colorado law, judges are required to value everything as close to the final date of the decree as possible. Property is divided in a divorce. We'll talk a little bit more about how that happens. But we're required to value things as close to the final divorce date as possible. Now, when you have an asset that's fluctuating wildly in value on literally an hour by hour basis, you have a unique challenge. Just before we got onto the program tonight, by the way, I checked the latest valuation of Bitcoin. And Bitcoin, as of a couple of hours ago, was trading at $85,000 per Bitcoin. $85,000. To give you an idea of the volatility, I intended to pull a chart and I couldn't quite pull it off in time, forgive me. But over the past 5 years, Bitcoin has multiplied in value by over 5 times. 5 years ago, these assets were worth about 20 grand. Today, like I said, $85,000. As recently as the start of this year, Bitcoin was trading at over $100,000 per Bitcoin asset. So you can imagine how challenging it is then for a judge to figure out what's a fair valuation. The tracking and the disclosure is really challenging. Like I said, we practitioners are used to looking at statements, investment statements, bank statements, what have you. Bitcoin, you're not typically going to have these statements. We're typically hiring financial experts to help us with this stuff. But even when we do, the tracking is far more difficult. And then you add in the very common problem we see in divorces about full disclosure with an asset which by its very nature is difficult both to find and to evaluate. And now you have a bigger problem than ever. My biggest advice to anybody in these situations is if you know these assets exist now or used to exist at some point during the marriage, alert your lawyer as soon as possible so you can begin having a conversation about how to find and value these assets and potentially bring in experts to help us do it. It's not easy. And fraud is sadly rampant. So let's look at how the law handles these assets, at least when we're able to find them and value them. So, like I said, cryptocurrency is an asset. Like any other asset in a Colorado divorce, it's subject to division if it's deemed a marital asset. Only marital assets are subject to division. Separate assets cannot be divided, and more on that in a minute. Cryptocurrency is classified as an asset. I mentioned that before, as opposed to a currency. And that has important ramifications here. So unlike money in a safe deposit box, or rare coins in a safe deposit box, or even bank account balances, these are very easy to value. Cryptocurrency is an asset, and it's treated like an asset, not just a money, a currency asset subject to division. In every single Colorado divorce, there's something called mandatory disclosure. It's required under the rules in all divorces. And in all of these divorces, each party has an obligation to disclose everything they have and everything they owe. And most of this goes back for 3 years prior to the date of the divorce. So everything obviously includes cryptocurrency. You're required, without even being requested, to disclose everything. You disclose statements if you can, and you're going to prepare a financial statement called a sworn financial statement that lists all of your assets, expenses, and debts. You are required to include digital assets in these disclosures. If we suspect it and we don't see it in the mandatory disclosures, we are going to issue what's called discovery, which are supplemental demands for producing documents and information. And there are other things we can do as well. And this goes back to please alert us as soon as possible if you suspect this stuff is out there, because there are other legal tools at our disposal, such as having a deposition. Bring somebody in, we put them under oath with a court reporter, and we often insist that they bring in documents, and then we simply ask probing questions to get more information and allow us to do other things like issue subpoenas when we find this stuff out. Really, really important. Again, inform your professional as soon as possible if this is out there. So let's talk about marital property a little more. Again, marital property is what judges are required to divide in a divorce, only marital property. So after you've done your mandatory disclosures, the first question your lawyer will attempt to figure out is what's marital versus what's separate. There's a statute there that governs the definition of marital property in the state of Colorado. In general, marital property is presumed to be everything that you acquire from the time you say I do to a marriage until the final date of the divorce. Regardless of the time of separation, marital property is everything you acquire, or we presume it's everything you acquire from the date of the marriage until the date of the divorce, unless it's acquired by gift, by inheritance, it's exchanged for a gift or an inheritance, or it's off the table by virtue of a valid prenup or postnup. A marital agreement can set the definitions of marital versus separate property different than what Colorado law provides. If you have a valid prenuptial agreement, that's going to govern the definition of marital property. And marital agreements are contracts, and people can agree so long as there's full disclosure and so long as there's no duress to define things in any way they see fit. So that is all of marital property. There's a few huge exceptions to these general principles, all of which, by the way, applies to cryptocurrency. Number one, how something is titled does not decide or does not force the judge's hand in terms of whether it's marital or separate. So it can be in the name of one spouse or the other, and it doesn't matter. What really matters is how it was obtained and when it was obtained. Number two, even if an asset is a separate asset, but it increases in value during the course of the marriage, the increase in value is deemed marital property. And this is really important when it comes to a really volatile asset like cryptocurrency. You might have a situation where somebody owned Bitcoin before they got married. Here it is 5, 6 years later, and the greatest amount of value is not the initial value, it's the increase in value, which could be 60, 70, $80,000 per Bitcoin. And those fluctuations, by the way, are not unique to Bitcoin. We see them in the other cryptocurrencies as well. Again, the valuation is to occur as close to the date of the final decree as possible. So typically, in a divorce, we're going to provide disclosures. We're going to, if we need to, hire financial experts to help us determine values as soon as we can. But then we're going to ask those experts to update those values as close to the final hearing date as possible, because things change so much. The next thing that we will have to do, which is really complicated, quite frankly, when it comes to cryptocurrency, is you have to trace these assets. Anybody, well, I shouldn't say anybody, but most investors in cryptocurrency do a lot of buying and selling and trading. And so you have to be able to trace one asset to the next in order to determine value in a fair way. I talked earlier about the fact that there's mandatory disclosure. Even if somebody's completely on the up and up and they're disclosing everything, what I've seen in cases is that this still gets to be pretty complex. Your lawyer shouldn't be the only one trying to decipher this stuff. You're going to need almost always a savvy financial expert to help you with the tracing. These experts that we are going to retain, by the way, not everybody can do it. Even the typical business asset valuators that we use, what I found is that not all of them are up to date on this stuff. We need to find somebody who really understands what they're looking at, what they're doing, and perhaps most importantly, what additional information and documentation we need. Sometimes the best advice is to ask the right questions so you can get all the answers you need. You're looking at analyzing these blockchains. Sometimes we're issuing subpoenas. We have to figure out where to serve those subpoenas. Not very easy. Let us know early and often, and we need to work together to make sure that we do the best we can in getting the full picture here. Okay. So there's challenges here in terms of the valuation that I've already referred to. This market volatility is an enormous challenge. The date of the valuation, again, that's a challenge. We're supposed to look at as close to the final date as possible, but lots of times we're negotiating an point in time that's well before that. So we're going to need to deal with, if we're able to reach an agreement, what happens between the time you reach that agreement and the time that that agreement in principle is fully drafted up in the form of a separation agreement. How you deal with changes in value in a time period that often is months between negotiation and final documentation, especially if the negotiation is ongoing, as you can imagine. Um, like I said, we're going to bring in experts to look at this stuff. And we need to make sure they have the proper expertise to help us. So how then does the judge deal with these assets when it comes to the final divorce decree? There's a few different ways to do it. So let's say we've gotten past the hurdles of locating the assets, valuing them, tracing them, and all that good stuff. Now we're trying to figure out what happens to these assets. There's a few different ways to handle them. One thing you can do is if both spouses have what's called a digital wallet, which is basically a personalized website address with some security features in it. You can transfer the cryptocurrency from one spouse to another. It's called one digital wallet to another digital wallet. You can just transfer all or a portion of the value that way. That's one thing you can do. Another thing you can do, which we see a lot in cases or situations, I should say, where the valuation is disputed or it's a bit unclear, sometimes the best recourse is simply to agree or to ask the judge to order that it gets liquidated and then divided in terms of the proceeds. That's one good way, if the liquidation is done in a fair way, to get maximum value to both parties. It's sold and then that's it. The value is the proceeds. And then you simply divide up those proceeds between the spouses. Another common thing we do with cryptocurrencies is we figure out value rather than trying to move the funds from one digital wallet to another digital wallet, or rather than ordering them sold. If we have value, we assign that value to the spouse who is keeping that asset, and then we compensate the other spouse through another way. This is very common. Colorado is an equitable division state. Equitable division, what that means is property is divided in as fair a way as possible, not exactly equal necessarily, but fair. And under the law, we can assign some assets to one spouse, some assets to another spouse. And the most important thing from a legal standpoint is that the bottom line, the value of the sum of the assets for each spouse represents whatever the judge deems to be equitable, which is usually, frankly, close to 50-50 in the vast majority of situations. So, hidden assets are almost always a problem in these cases. So what do you do if you think that there might be cryptocurrency and you don't know what it is? First of all, how do you even know? It is my experience that most times only one of the spouses is very knowledgeable about this stuff, not the other. That doesn't mean the spouse with less knowledge should get hosed. They definitely shouldn't. But things to think about and listen for would be any time your spouse has referred to any of these things in the past. If it's not in the disclosures, but there's been talk about it at any point in the past, I'm going to strongly advise you to talk to your professional and have your professional, your attorney, ask further questions. So there might be statements about it. Another sign that there might be cryptocurrency that we have seen is when there are odd entries on bank statements. Now, what do I mean by that? I mentioned earlier that typically cryptocurrencies are not going to appear on traditional looking um, statements, the kinds of statements you'd see from retirement accounts or bank accounts. But what if on these more traditional accounts, you see odd entries such as withdrawals out to an unknown or weird sounding payee? When we scrutinize bank statements, we're looking for this stuff. We'll go over them with our client. And when you look at your soon-to-be ex-spouse's bank statements, you should be able to identify, at least for all of the larger transactions, where the money goes for every single line item. And sometimes you'll see abbreviations, you'll see odd things, you see people's names. And by the way, we see some of these things in Venmo, cash pay kinds of transactions. If the recipient is unusual, all you need to do is highlight it and then let's ask the questions and let's demand the answers. You're not always going to see Bitcoin listed as Bitcoin on a bank statement. Same with some of the others. These assets are often traded not just with the central entities that run these cryptocurrencies, but there are private trading locations through which these are bought and sold. You don't need to know all of them. Nobody knows all of them because there's new ones all the time. The point is, if you see something fishy or something you don't know, let's highlight it, let's flag it, and then let's ask some more questions. If the other side is not cooperating, whether it's cryptocurrency or any other kind of asset, you have remedies. You have legal remedies. We can file a motion to compel. We can get a court order that somebody must disclose. We can get attorney's fees for going through the trouble of it. One spouse who's hiding can be penalized. The judge can assume certain assets exist if the judge has reasonable grounds to believe they exist. And if that happens, let me tell you, the penalties are often not just the value of that asset which somebody is trying to hide, but damage to that spouse's credibility for everything else. Once we find somebody who's playing games, their honesty is going to be strictly scrutinized on everything else, including, by the way, when it comes to child custody issues. When you go in front of a judge in a court of law and you're sworn to tell the truth, and you're found to be misleading or hiding things, everything you say is subject to scrutiny, including what you're going to tell the judge is in the best interest of your children. It's very dangerous. It's very bad. Judges come down very hard on these kinds of things. And the consequences are really far reaching, like I've mentioned. So some things to avoid based on some of the stuff we've gone over thus far. If you think this is out there, it is a huge mistake to not fully investigate. Do not take your soon-to-be ex's word for it. That may seem like such a no-brainer for most people, but it's not. You're stressed, you're afraid, maybe you're worried about attorney's fees, maybe you just want to get to closure. And I get all that. People are in bad spots, obviously, when they're in the family law courts. But please, you don't want to be making decisions that really can have long-term financial decisions without full investigation at least, so you know what you're potentially giving up. Another mistake is to not value these things properly. It's very important to get the right advice. Tax implications are a bit unique when it comes to cryptocurrency, and failing to account for tax implications is another huge mistake. This was going to be my fancy chart, which I apologize, I couldn't quite pull off. But trust me, this chart has a lot of up and down, in terms of the 5-year valuation. What you will see, by the way, is mostly it's trending steeply upward from 20-ish thousand to 100-ish thousand. But within periods of time, there's a lot of this stuff. Okay. So what about the taxes? What is unique about cryptocurrencies? First of all, these are treated like property assets, not currency assets. Therefore, you have to worry about capital gains. If somebody sells a cryptocurrency asset, they only hold it for a year or less, you're subject to significant short-term capital gains taxes. If you hold them for more than a year, your tax rate is a bit lower. You're looking at longer-term capital gains. I tell you all these things, by the way, just to alert you, just to kind of flag this stuff. I'm not a tax expert. I don't play one on TV. We do have a tax expert in our firm who can advise us on this stuff, who we'll often go to, but you're going to want to ask the right questions. Next, since these are assets, if you're transferring cryptocurrency from one spouse to another at the time of the divorce, that transfer by itself is not a taxable event. So again, at the time of the divorce, if you're moving cryptocurrency, for example, from one digital wallet to another, the mere act of the transfer is not a taxable event. It's only a taxable event when that asset is sold or liquidated. So what you're going to want to think about is, if you receive cryptocurrency in a divorce, your tax basis goes back to the date your other spouse purchased the asset. So you might be thinking you've got this great deal that Sally bought it at 20 grand and you're getting it today at 80 grand. And that is a good deal, but you need to account for in the settlement, or ask your judge to do so, the fact that someday, if you choose to liquidate that, you're going to pay capital gains, not just on the increase in value from the time you got it in the divorce, but all the way back to the original $20,000 valuation. That's really important. The other thing you want to be thinking about is assets are assets, revenues are revenues when it comes to the IRS. There's specific reporting rules. If your other spouse is the one who's been handling this stuff, you're going to want to have protections in your final separation agreement, because hiding this stuff or being accused of hiding it can be tax fraud. And even if you're not the one primarily responsible, it's potentially a bad deal when it comes to an audit. Again, when in doubt, consult a tax professional. And what I would say overall here is that you're going to want to consult a tax professional about any of this stuff, because this is a very broad overview. What I'm telling you today, today's the 19th of March, 2025. If you're looking at this on our website in the future, realize a lot probably has changed. What I'm telling you today could be outdated in the future. So please, please be careful. Ask the right questions. Speaking of the right questions, I'm going to pause and turn it over to Izzy and see what questions you all might have for tonight.
Awesome. Thank you, Rich. And just a reminder, you can put your questions in that Q&A at the bottom of your Zoom screen here, but we have a couple from before. Alrighty, the first one is, and we had a couple on this same vein. I would like more information on how to get access or find the crypto that they are trying to hide. Lots about hidden crypto. So maybe you can touch on that again.
Absolutely. So this is the biggest question that we always have to deal with. Even if there's not, even if people aren't hiding stuff, we're always worried that they could be. I mean, by their very nature, crypto means hidden, and it's easier to hide this stuff than a lot of other assets that are tangible. How do you prevent it? There's no great way to prevent it, but like I said, the most important thing is to begin asking the right questions. Sometimes best thing we can do if we think somebody's being squirrely is we just subpoena them to a deposition. We sit them down in a conference room, put them under oath, and then we just go after them, and we ask a wide-ranging series of questions to delve deeper and deeper. And sometimes it makes sense to have our financial expert available for consultation. Sometimes we have a whole trove of documents that I got to tell you, as a lawyer, that's not my main expertise to be able to decipher this stuff. We're going to bring in somebody else with this expertise to look into it and figure it out and help us, very importantly, determine whether there might be other documentation that is missing. One other thing I'll say on this subject is, there's no, I'm going to say two things, actually, forgive me. Number one, there's no one way to do this. Each of these cryptocurrencies are unique. What we can get out of the companies will vary. Whether they're even subject to subpoena is going to vary. So that's one piece of it. The other piece that I want to offer, perhaps to give a little bit of cold comfort here, is that in a worst case scenario, if the other side does not disclose, in most cases, you have a 5-year window for fraud, where even after the divorce is complete, if you obtain information after the divorce and you can prove that the other side didn't disclose, you can go back to court and either reopen your settlement or file a motion with the judge to ask for new or different orders, plus penalties for the non-disclosure.
Amazing. That was the second question that I just got was, what if I find out about hidden crypto after our degree is finalized? And is that for all assets that we find later? Is the 5-year rule?
Great question. Yes. The 5-year rule applies to all assets. And we get these questions fairly commonly, by the way. Sometimes people just aren't sure. If that's the case, give us a call. Let's sit down. Let's talk about it. Let's figure out whether we need to ask further questions. Because the 5-year look back is a really powerful tool. In some cases, we know or we can prove that an asset exists, but we don't know what the extent or the value of that asset is. And that would be very common in a cryptocurrency situation where, all right, now we have proof that somebody owned Ethereum because we've identified something on a bank statement. We can tie it back to Ethereum, but we don't know how much it is. All we can see is, all right, at some point they had this. We don't know if they still had it at the time of the divorce. We don't know how much is in it, but that piece of information alone may be enough to file the proper motion with the court and then give us the tools to engage in further litigation, including depositions, subpoenas, other discovery, other tools at our disposal. It's a really powerful remedy. So again, I think that what you do at the time of the divorce is you push as hard as you can. You ask the right questions. If you can't succeed, know that you have this fallback remedy.
Great, thank you so much. Okay, and then we have a question not related to crypto, but still very important and on everyone's mind. What are the best ways for me to protect my retirement funds assets in a Colorado divorce?
Okay, great question. The question is, how do I protect my retirement funds in a divorce? I'm gonna give some broad advice here, which actually applies to cryptocurrency as well. One of the important considerations that one should think about if one is concerned about these assets, whether you hold them or if the other spouse holds them. A lot of times people come to see us prior to filing and they think the other spouse is engaging in shenanigans and they're liquidating stuff. You have protection under the law once you file for divorce and serve the other party. Once the other party is served with the papers, there's an automatic order that goes into effect that freezes everything. And it says that you can't squander things, you can't hide things, you can't even make unusual transactions out of the necessities of life or day-to-day business. So if you're the spouse where you're worried about the other spouse playing games, our advice to people is even if they're not 100% sure they want a divorce, it makes sense to go ahead and file. Maybe you even file for legal separation. You get this mandatory order in effect. Now, let's say you're the spouse, and I'm gleaning perhaps from the wording of the question that you might be the spouse that holds these assets. So you have a retirement account, you want to protect it. So you protect an asset like any other asset by trying to get the most fair property division you can. A retirement plan is subject to division. Remember the rules, however, that it's only marital property. Or it's an increase in value in separate properties. So you protect yourself by making sure you're excluding from division all of the separate value in your retirement account. There are other things you should be doing, including making sure the other spouse fully discloses all of his or her assets. So remember, you can trade one asset for another. If you have $100,000 in retirement, it's not necessarily the case that you're going to have to give up 50,000 if there are $50,000 of value in other assets, including the assets on the other side. An important way to protect yourself is to make sure that your other spouse is not hiding or undervaluing their assets. That's really critical because the reality is everything is subject to division. You just want to make sure it's done in the fairest way possible. Anything else, Izzy?
That was the last question. You covered it all.
All right, fantastic. Well, let me close on the following. Key takeaways, everybody. First of all, thank you for attending. And make sure you ask the right questions. I'm really glad you're here tonight. Chances are you're on the right path already just by getting informed. If you think these assets are out there, make sure you ask the right questions and be persistent. That's the best way to ensure that your rights are protected. Beyond that, there's lots of nuances to this stuff. We're happy to help anybody after tonight with specific issues and their specific situations. Izzy's going to tell you about how we can help you in just a moment. But from my end, I thank you and I wish you a very good night. Thanks so much.
Thank you, Rich, and thank all of you for attending. In order to get those more specific questions answered about your specific cases, we'd like to offer you a free consultation. Just give our offices a call and give them the code Wiser Together, or just mention the webinar, and they'll get you set up with that free consultation with one of our attorneys. I'll reiterate what Rich said. We hope you have an excellent evening. We wish you peace, and we hope to see you at another Wiser Together webinar. Have an excellent evening, everyone.